This is the story of a crisis in corporate law, the struggle over a solution, and how a Delaware statute, Section 102B7 of the Delaware General Corporation Law, was devised to solve the problem. The story has a happy ending, but the beginning of the story was decidedly unhappy. To tell the story, we'll hear from 5 Delaware lawyers who played key roles. A. Gilchrist Sparks III, who chaired the group of Delaware lawyers that crafted the statute. Edward McNally, who was a member of that group and conducted the interviews you'll see. E. Norman Vesey, a member of the drafting group who became Chief Justice of the Delaware Supreme Court after our story concluded. Stephen P. Lamb, a member of the drafting group who later joined the Delaware Court of Chancery, and Joseph A. Rosenthal, also a member of the drafting group and a leading lawyer for plaintiffs in stockholder litigation. The story begins in 1985, a year that brought new and frightening challenges for directors of publicly traded companies.
In the 1970s, there were 13 hostile takeovers. In the 1980s, there were 150 hostile takeovers. What do you recall were the concerns of directors of public companies in the 1980s?
We were all involved in those takeovers that were being litigated in Delaware, and we spent a lot of time talking to the directors about how they really felt about this, and they wanted to spend more time on the governance aspect than worrying about lawsuits, but they had to worry about lawsuits because there were lawsuits going on all over the place, and particularly involving what happens when there's a hostile takeover. What's the duty of the director of the target company? There was a lot of angst among directors about that duty.
That angst seemed to be traceable in part to the Delaware Supreme Court's startling decision in January of 1985 in Smith versus Van Gorkum.
It was the first case in which any Delaware court had ever, in circumstances like this, held members of a public board of directors liable for the way they conducted themselves in connection with, in this case, it was a takeover. And there was a very long litigation that went back and forth to the Supreme Court a couple of times, which ultimately resulted in a finding of liability. And it was substantial. I don't remember what by today's numbers, it doesn't look like so much, but it was millions, maybe $10 million, something in that order.
Worse yet for directors, insurance that would protect them against liability was in a state of crisis. The 1985 Survey of Directors and Officers' Liability Insurance, published by the Wyatt Company, showed that such insurance was getting harder to find and much more expensive.
Premiums really in the period starting about the fourth quarter of 1984 and accelerating into the early part of 1985 were increasing on renewals by a rate of approximately somewhere between 50 and 100%. So premiums were going up dramatically, and coverage, the potential coverage that you could get was going down. Some primary insurers were going out of the market. Others were decreasing the amount they would write on a primary policy. And a lot of the reinsurers were simply dropping out of the market. So one set of figures that I can remember seeing during that period of time was that if you were a high credit and you wanted to build up as much D&O insurance as possible to cover your directors, in the sort of the pre-tightening, sort of the 1983, early 84 period, you could probably accumulate something in the range of $250 million by layering on a primary and a lot of excess insurance. By the time we got to early 1985, that number had decreased dramatically below $100 million, and there was a particular effect on certain industries, the petrochemical industry, the financial industry, the insurance industry. Those are the ones I remember being, in some cases, almost impossible to get insurance because the risk was perceived to be higher.
Was this insurance crisis a response to the Delaware Supreme Court's decision in Smith versus Van Gorkum? Doubtful. But that case certainly contributed to the atmosphere at the time.
What I do know is that the trend started before Smith versus Van Gorkum. So sort of the myth that some have perpetrated that this was a reaction to Smith versus Van Gorkum, probably not right, because all of this began before that, as the Wyatt report suggests. But on the other hand, with this increase in hostile takeovers and a perception that there was a possibility or greater possibility of director liability with large numbers than there had been before, it would not be a bad supposition to say that the insurance market recognized that also and were attempting to shore up, if you will, what had been a relatively sleepy corner of insurance law when they started to have to write checks from time to time.
So what did the insurance situation mean for directors of Delaware's many public companies?
The problem for a corporate director, as opposed to running your own affairs, let's say, is that you are often called upon to make decisions that have very enormous financial consequences, consequences that can dwarf your own net worth. And even for high net worth people, it's a very, it's a proposition in which you're getting paid at this time $10,000, $20,000, $30,000 a year, and you're exposing yourself to potentially tens of millions of dollars of liability. And so it's pretty it's a little hard to understand why you would agree to do it.
So while I don't believe Van Gorkum was a cause of the insurance crisis, which we've already discussed, the fact that Van Gorkum was out there coupled with the insurance crisis certainly created a level of anxiety among directors that hadn't been there before when you put the two together, and gave rise to what really drove our concern in looking for a solution, and that is that if directors decided that they weren't going to put their personal fortunes at stake for a directorship position in a public company because it was just too risky, then we would end up having a slippery slope in which the quality of directors of Delaware corporations would decline.
And this problem came at a time when courts and governance experts were increasingly calling for greater participation by directors who were independent of corporate CEOs and other insiders.
Our Supreme Court was making it very clear in cases like Unical and Revlon and the cases that came along, but it was you could already see the trend in Weinberger versus UOP with the emphasis given to a special committee of outside directors, that the emphasis was switching to having boards that had a majority, indeed a vast majority, of independent outside directors.
Both the federal government through the SEC and the Delaware Supreme Court were pushing for there to be larger proportions of independent directors on corporate boards. So it's one thing for the president and the senior executives of a company and maybe the family member who controls the company to sit on the board. All of their interests are at stake. It's something else to get an outsider to come in and expose his or her net worth to liabilities arising out of that activity. And so there's this pressure to get more independence on the board, the idea that you're now going to get more of them on, have what you think is a better board process, and then expose them all to basically unlimited liability was at some tension.
All this tension resulted in a lot of pressure on Delaware to provide a prompt fix in the form of legislation to protect directors from at least some liability.
Pragmatically, there were two threats not on the horizon. They're really in the forefront of what was happening in corporate. I call it corporate America, but that includes the legislators. One was the threat that other states would jump on the problem and make life much easier for corporations and directors to do business in their states. So if we wanted to retain the primacy of Delaware and not, as Professor Carey said, engage in the race to the bottom, we better do something fast. The second theme was there was a considerable movement on the part of corporations to propose their own legislation to the General Assembly, which is just an unheard of thing in Delaware.
In this environment, the Delaware corporate bar responded the way it traditionally did when the Delaware General Corporation Law might need changing. The task initially fell to the Council of the Corporation Law section of the Delaware State Bar Association.
And the council's role in connection with the corporation law was what? How would you describe it?
We drafted and recommended proposed legislation to the Bar Association as a whole, and then that proposal, if carried, would go to the legislature. And I'm pleased to say that the legislature respected the recommendations of the council and the bar, and was very, how shall I put it, let me say, welcomed, our contribution to the development of Delaware corporation law.
The Delaware Council also got a lot of input from people outside of Delaware, including the American Law Institute, or ALI.
Did the council consult with law firms across the country and dealing with various issues that came up?
Yes, we would reach out, and individuals on the council would reach out to their clients and to other interested people, law professors and the like, who might have a view, so we could not be doing this in in sort of isolation, but would know what kind of reaction we might get.
So it's just not a Delaware thing. It's a thing that, you listen to people all around the country.
Listen to people all around the country, and this was a perfect example. My file, which blessedly still remained after all these years, contains correspondence from a broad variety of sources. People working with the ALI, major corporate groups. In this case, there was a major corporate group headed up by Squibb, which had 30 or 40 other general counsels thinking about this problem. There are comments from law professors and other practicing lawyers in other jurisdictions.
In this fertile environment, quite a few ideas were teed up, but most got quickly rejected. One idea was to enable corporations to reimburse or indemnify directors if they were held liable.
That solution, which wouldn't have been a solution at all, really, to the problem that people were really facing, had big policy problems with it. That's a circularity thing. If you think about the public perception of a trial occurring, an appeal occurring, and directors being found liable and told by the court that they were obligated to write a check, let's just hypothetically, a check for $10 million to the corporation for whatever misdeed they had done, whether it be a loyalty violation or a care violation or whatever. And then the corporation is permitted the next day, after going through a process, to write a check back to them for the same $10 million. That just is an unviable concept.
I think the council took a very responsible attitude toward all the issues that came before it, but particularly this one, and they just didn't want Delaware to appear to abandon all rights of corporations, shareholders, investors, by just saying to directors, you do whatever you please and we'll indemnify you, and you have the circularity problem, which we're all aware of.
Circularity meaning the corporation, there would be a damage award in favor of a corporation, which the corporation wouldn't ultimately have to pay.
That's correct.
Another idea that didn't get off the ground was enacting a cap on director liability, an approach that the state of Virginia had already adopted, and that influential corporate lawyer Martin Lipton was advocating.
I know that in April of 1986, a prominent lawyer sent you a proposal that dealt with a damage cap of I think it was $1 million at that point. What was the reaction to the general idea of damage caps?
Well, there was mixed reaction. Obviously, there were some who were enthusiastic about it, including, and it was more than one that sent us a proposal along that way. There were just as many who were concerned about it for various reasons. One reason was that nobody could agree on what the cap ought to be. $1 million, $100,000, and that would obviously have different impacts depending on how wealthy the director was. There was a problem in terms of what was going on at the same time in the legislature. There was a tort reform activity going on, and the Bar Association was generally opposed in this tort reform activity to an imposition of caps of liability
For tort claims.
For tort claims. Yeah. So there was a concern, and I'm sure that this was a part of a concern that we later saw from Mr. Crompton, Charlie Crompton, who was president of the Bar Association, and he has one of his sections off here considering seriously a cap on director liability in certain types of cases. And he's got another section which is lobbying for no caps in the area of tort reform, and it doesn't lend itself to be a very consistent position.
That created a real problem for the Bar Association to be, on the one hand, be supporting a cap for director liability and opposing it for everybody else. So that does seem to be a significant political problem.
Do you recall much about the discussions concerning the desirability of a cap on liability for directors?
I don't, but I think that was shot down pretty readily, as I recall. Because if we put a cap on, then some other state would put a lower cap, and then pretty soon there'd be zero cap, and it's that kind of thinking, the sort of parade of horribles argument that it would not help matters, it would make it worse, in fact.
As it turned out, the idea that did get traction was from the American Law Institute, or the ALI.
Now, there did, in this period of time, come across the transom, and then we go back to the ALI, a proposal that at least I think ultimately became the structure that we adopted. And it came in the form of a communication to both Norm Vesey, Lou Black, and ultimately to me directly from Marshall Small, who was a prominent lawyer with Morrison and Forster in San Francisco, and was on the group at the ALI that was considering how to handle this issue in connection with their corporate governance project that I mentioned, the broader corporate governance project that I mentioned. And they shared with us, and I shared with the committee, the council in early March, a structure that looks a lot like what we ended up with in 102B7. It basically said you can put in a charter amendment that limits the liability of directors, and then it listed a bunch of things that basically, just like ours, when you sorted out all the things that you couldn't do, left the duty of care as what was left. But it had a feature in it. It had a feature in it that we ended up not doing, which was saying, but you can't limit it below what the director's personal benefits were from the company for that year. So you in effect had a 102B7, but you couldn't take it down to zero. You had to leave some liability for the director, which made it sort of a hybrid cap statute.
The idea that stockholders would have to approve any limitation of director liability by voting for a charter provision establishing such a limitation, or by buying stock in a company with such a limitation already in place, was important to the leading stockholder plaintiff's lawyer on the council.
And from your point of view as I'll just put it to you, stockholder's lawyer, was it important that the stockholders have a point of view or a say in exculpating directors for negligent acts?
Yeah, the proposal was to either have it in the original certificate of incorporation, or in a provision in the corporate documents that the shareholders would vote on, and that's the way the proposed legislation was written. If the stockholders wanted it, that's fine. Realistically or pragmatically, that's really not satisfactory. You've got a large corporation, and they solicit shareholder approval. Back in those days, at least, and that may be true beyond those days, back in the 80s, shareholders generally did what management or approved what management proposed, but nonetheless, it was the shareholders saying this is okay.
What wasn't in this charter-based exculpation proposal was coverage of corporate officers as opposed to directors. This wasn't an accident.
I was against extending it to officers since the object of our exercise from the beginning had been to make sure that we could attract qualified outside directors to continue to serve as directors of Delaware corporations. And we simply didn't need to do that with respect to officers who were well paid, and nobody had ever heard of a situation where an officer had declined to become an officer because he didn't have D&O insurance. The officers weren't the ones who were complaining, and our theory, our purpose in all of this was to encourage people to serve, and you didn't need to do that for officers. And the other issue that I thought was important was that by not extending it to officers, you would cause officers to do what they ought to do on sticky problems and bring them to the attention of the board, so they could be dealt with at that level.
But the proposal did include one phrase that caused some confusion later on: the provision that the charter couldn't preclude director liability for action, quote, not in good faith. What did that mean? And where did it come from?
I noticed in the statute that there is a provision in there that talks about not in good faith. Do you recall a discussion about that? Who proposed that, why it was proposed, and what was said with respect to it?
And then I do remember, to get back to your question, a meeting at Morris Nichols' office, which at the time was over in the IMP building, at which, maybe it was the final meeting to consider this, at which Mr. Rosenthal said that he believed that statute should include, as one of the things you cannot exculpate, was a breach of the duty of any action not taken in good faith. And I remember that discussion because it was a couple of reasons. I mean, my view of it was that things that are not in good faith violate the duty of loyalty. And so it was, to me, surplusage. And it didn't need to say that. I thought since it was, to my mind, surplusage, it created some risk of
ambiguity
and hazard in putting it in the statute, because it meant there now was going to be an argument or having to go through some process of deciding what this duty of good faith became. And it was presented in the negative as actions not in good faith. But Mr. Rosenthal was quite insistent that it needed to be in there to gain his support. I think there was a lot of unease among all the other members of the council in the room, but in the end, people agreed to put it in there.
Getting the council's approval, however, was certainly not the last hurdle to clear. The next one was approval by the Delaware State Bar Association.
Mr. Charlie Crumpton at that point was the president of the Bar Association, is that right?
He was president of the Bar Association.
Why did you have to meet with him then?
Well, I think he began to get uncomfortable, and by this time we didn't have anything we had decided on. But I think that the proposals that were out there, which included a cap, and which we would have put in legislation in 146, or perhaps a variant that we were working on in 102B7, all involved this cap idea. And I've already explained to you that he had broader concerns than just our work, and his initial reaction was negative. And I was asked to talk to him about it and explain where I thought we were headed.
And then after that, what happened next?
We had a meeting on April the 23rd, and and Frank Bellotti and I had met with Charlie Crompton, and we had at least gotten him to a point at the minutes recite, probably as accurately as I can remember. Although Mr. Crompton was not necessarily persuaded to support the council's legislative proposal on DLO liability and indemnification, he has an open mind on the matter and has agreed to work with us. And then we had some assurance that we would have some legislative cooperation.
Once the Council and the State Bar Association approve amendments to Delaware's corporation law, it's usually clear sailing for approval by Delaware's legislature, the General Assembly.
For the most part, these amendments presented to the Delaware General Assembly have gone relatively smoothly because the members of the General Assembly who focus on this know that the Bar Association Council, Corporation Council, has spent a lot of time in debating these things and examining how they are perceived all over the world, because Delaware's corporate franchise is the most important asset Delaware has. And it's very important that we keep that ship on an even keel. And they know that, and they know that we and the Delaware Bar Association are paying attention to that, and that we do a balanced job that's been vetted throughout the country. So they usually take what we say, as being carefully vetted.
Usually, maybe. But in this case, legislative approval was threatened by the late emergence of a powerful voice in opposition to the proposal, from Bruce Stargett, a widely respected and senior member of the Delaware law firm of Young, Conaway, Stargett, and Taylor. As Mr. Stargett saw it, the Council's legislative proposal would do nothing less than completely eliminate the director's venerable fiduciary duty of care. Others didn't see it that way.
Bruce was viewing this as a change to the substantive law, and we had been very careful and strongly believed that we were not changing the substantive law. In other words, we were not in any way reversing or changing anything that the Delaware Supreme Court had said in Smith versus Van Gorkum. We were leaving that all in place. So if you didn't pass the charter amendment, and it was a monetary damage case, there would be no difference between that and a full-throated approval of implication of or application of Smith versus Van Gorkum. In an injunction context or a rescission context, we weren't touching any of that, so the teachings in Smith versus Van Gorkum would have full application there. And that's important because many of these takeover cases were decided in the context of preliminary injunction practice before the merger, and 102B7 would have nothing to do with that.
Norm Vesey sent a memo to the members of the Corporation Law Section ahead of its vote on the proposal, taking issue with Mr. Stargett's views and urging support for the proposal. He argued that the duty of care would have continuing vitality in remedial contexts other than personal monetary damages against directors as individuals, and would be vitally important in injunction cases seeking to undo or rescind wrongful transactions, and in cases involving the process for electing or removing directors. The Bar Association agreed, voting in favor of the proposal by a large majority. But even that wasn't the last hurdle.
The problem was that Bruce Stargett indicated that notwithstanding the fact that he had put his position out and had lost 31-8, if you will, at the section meeting, that he was now going to carry the fight against this on to the legislature.
That meant that the proponents of the amendment had to mobilize support in the General Assembly. They turned first to Representative Charles Hebner on the House side.
I talked to Hebner, who was then the Speaker of the House, and I think he was on a committee that considered that. And he and I had a lot of dialogue along the way about this 102B7, and I think he was satisfied.
On the Senate side, however, approval from the influential President pro tem of the Senate, Thomas Sharp, was not a slam dunk.
We had already spoken to Representative Hebner, and I believe we were sort of in good shape in the House. But Sharp had been asked to sponsor the bill. And he was the one we would normally go to, given his position, to get sponsorship on our routine proposals. And he had initially said that he would be willing to serve as a sponsor. But then he talked to Bruce Stargett and learned of his opposition to the bill. And his sponsorship was in doubt. And we recognized that without his sponsorship, I think the thing maybe wouldn't have even gotten out of committee.
What happened next is a classic story of how things get done in a small state like Delaware, where the key policymakers know each other very well.
There was a discussion about the fact that the tradition had been among members of the council that if and the section that if you had your say and your position was not sustained at the section level, that it was sort of a gentleman's agreement that you wouldn't oppose the thing in the legislature. That was had for a long time been the way we operated. So there was a discussion about that. And then I had received a call from Charles Welch. Charles Welch was then the general counsel of the DuPont Company. And he, along with the Squig Group, and really most major corporations had been following all this with some degree of interest. And while we weren't doing exactly what those groups wanted, they recognized that what we were doing was much better than the situation they were facing otherwise. And so we seemed to have general support from the corporate community. We knew that by the time we had gotten to this point. Mr. Welch had asked for the privilege of speaking to the committee. He was homesick, but asked if he could speak by speakerphone. He did that and explained that he also knew Senator Sharp well and was hopeful that Senator Sharp could be persuaded to permit the draft bill to be introduced and voted on in this session. And then he went on to say that if for some reason we didn't introduce it, he would introduce it independently, and if the bar didn't, well, that was a fairly strong statement. And all I can tell you is that between May 28th and June 2nd, Bruce Stargett dropped his opposition to the bill. He wrote a letter, which is in the file, explaining that he wasn't wholeheartedly in favor of the bill, but they did understand the traditions of the bar and that he would, under the circumstances, withdraw his opposition. Now, I'm not going to speculate about what sort of interaction there was between, and whether he was persuaded by the meetings that we had with him, whether he was persuaded by Chuck Welch's position, whether Senator Sharp was involved or any of that. I have no idea. All I know is that by the time Memorial Day was over, the horizon was brighter and I was happier.
And with the withdrawal of Mr. Stargett's opposition, the path ahead was clear, and the rest of the story is the happy ending. As Mr. Sparks anticipated, investors readily supported the adoption of provisions eliminating monetary liability of directors.
There was some concern, I think I recall, that stockholders wouldn't approve a 102B7.
Right.
How did that work out in the real world?
In the real world, they approved it overwhelmingly. And there was that concern. But I think that stockholders at the end of the day were persuaded that we're freeing the directors to govern these enterprises, and that they shouldn't have to worry about these lawsuits, these nuisance suits, and that they should focus on the important stuff, the big stuff. And I think that I was surprised at the overwhelming reaction of most of the stockholder base of the Delaware corporations to Section 102B7, and it went through very well. It's been adopted almost universally.
And as it turned out, literally, I mean, not every corporation, but a huge percentage of corporations put this on on their ballot, if you will, for the next spring's proxy season. It was just a routine proposal, and I don't know of any corporation where the proposal was rejected. And it's since become a rarity to find a public corporation in Delaware that has not adopted 102B7 in a full-throated way.
And despite near universal adoption of these anti-liability provisions, stockholder rights, at least according to Mr. Rosenthal, haven't suffered much, if at all.
You had mentioned that 102B7 did not have a dramatic effect on curtailing stockholder rights in litigation. And why did you feel that way?
Well, I was concerned that it would cut off some. And I think history showed that it really didn't cut off any. I mean, it was always thrown in as a defense, but it really didn't affect litigation, at least from my perspective, what I was able to see on the litigation front. And the reason is, as I said, the direction we were going as plaintiff's bar was on class actions, mergers and acquisitions, and M&As, and they really were not affected by 102B7 because in those cases, this is one of the reasons, just one of the reasons. In those cases, the corporation generally was a real defendant, unlike derivative litigation, where the corporation was only a nominal defendant. And and you had the parties to the merger agreement itself, not the shareholders, but the parties to the merger agreement, who could also be brought in. So there were a lot of people to sue and to make sure that justice was done without worrying about whether or not the directors were individually liable. When I say not worrying about, not having to wrestle with the procedural problems of trying to impose liability on the directors individually. So it's a whole new ballgame.
A new ballgame, maybe, but ultimately very much in the Delaware tradition of consensus and continuity.
And so is it your view that this legislation really was a continuation of the Delaware tradition of reaching a correct balance between stockholder rights, et cetera, and it ended up being almost universally accepted as the right thing to do?
Right. I think it's been completely non-controversial since it was passed. I had the opportunity in preparing for all this to go and pull my file and look at this progression of events that we've talked about. I thought the deliberations, the respect for various views, and the way we got to a solution in the end were the epitome of how I would hope that the council would always act, and to my knowledge pretty much has. I think this was a good exercise in terms of both reaching out, getting views, respecting other people's views, and coming up with a solution that really worked.